Clarence Earl Gideon was a poor man from Hannibal, Missouri, who is not well known to most people. However, he took a legal stand over 50 years ago, which still impacts our judicial system even to this very day. Today, because of Gideon, we recognize the phrase, "You have the right to an attorney. If you cannot afford one, one will be provided for you." Gideon was a poor man, a drifter, who in his own words led the life of a hobo and a tramp. With only an 8th grade education, plus a history of stealing and jail time, Gideon once wrote that he was not proud of his biography. Therefore, it may seem strange that he has been referred to as an unlikely hero, a world shaker, and the man who changed judicial history. From 1961 to 1963, Clarence Earl Gideon stood up for the constitutional right to a court-appointed attorney, especially for those criminal defendants too poor to afford one.
On June 3, 1961, Clarence Earl Gideon was arrested in Panama City, Florida. He was charged with breaking and entering into the Bay Harbor pool room. Reported stolen some wine and change from the vending machines. Gideon maintained his innocence. He had no money for bail, so he was kept in the county jail for 2 months awaiting trial. He had no money for a lawyer either.
The next case on the docket is the case of State of Florida versus Clarence Earl Gideon. What says the defendant? Are you ready for trial?
I'm not ready, Your Honor.
Well, why aren't you ready?
I request this court to appoint counsel to represent me in this trial.
Well, Mr. Gideon, I'm sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense.
Therefore, Clarence had no choice but to represent himself as his own lawyer. But, despite his best efforts, he was convicted and given the maximum sentence of 5 years in jail. Gideon was persistent and never gave up after his conviction, continuing to maintain his innocence from prison. Though not well educated, Gideon was far from dumb or ignorant, and he studied the law from behind prison bars. On lined prison stationery, he first handwrote an appeal to the Florida State Supreme Court. This petition for a writ of habeas corpus claimed that Gideon had been unlawfully imprisoned, but it was denied. Undiscouraged, Gideon didn't stop here, though. He then wrote a 4-page letter to the United States Supreme Court. From his prison cell, Gideon argued, "It makes no difference how old I am, or what color I am, or what church I belong to, if any. The question is, I did not get a fair trial. The question is very simple. I requested the court to appoint me an attorney, and the court refused." Gideon held fast to his belief that an attorney should have been provided for him, upon the basis of the 6th Amendment, which states, "In all criminal prosecutions the accused shall enjoy the right to a speedy and public trial, and to have the assistance of counsel for his defense."
I always believed that, and I thought that was actually a law. I thought that was a constitutional right, and I didn't know no different. The man with money can hire a lawyer to represent him. He'd get a better chance in the trial than I would get without an attorney. To me, that was just common sense. There was no argument to it.
Washington attorney Abe Fortas was appointed to represent Gideon before the Supreme Court. Fortas argued that the 14th Amendment requires a fair trial. He specifically focused upon the Due Process Clause of the amendment, which prohibits state and local governments from depriving persons of life, liberty, or property.
Every man, the rich, the poor, and the poor as well as the rich, was entitled to the benefit of counsel when he was defending himself against prosecution by the mighty forces of the state.
Fortas argued, how could a common man who has had absolutely no training in the law possibly be expected to go up against a trained lawyer? Fortas also said there is no such thing as a fair criminal trial where the defendant is not represented by counsel. On March 18, 1963, all 9 of the Supreme Court justices unanimously agreed with attorney Abe Fortas and ruled in Clarence Earl Gideon's favor, saying that lawyers in criminal courts are necessities, not luxuries. The court ruled that the Sixth Amendment's guarantee of counsel is a fundamental right essential to a fair trial, and applies to the states through the Due Process Clause of the 14th Amendment. Justice Hugo Black in the court went on to rule that it was an obvious truth that in our system of criminal justice, any person hauled into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him.
Even though the Supreme Court reversed Gideon's conviction, he did not go free immediately. Instead, he was given the opportunity for a new trial, this time with a lawyer.
It showed the difference between not having an attorney and being with an attorney.
Gideon was acquitted of all the charges against him and found not guilty. After 2 years of being in prison, Clarence Earl Gideon was a free man. After being freed, a reporter asked Gideon if he had accomplished something. "Well, I did," Gideon replied. In 1964, Gideon's heroic story was written about by New York Times journalist Anthony Lewis. Then, in 1980, Gideon's story inspired the Hallmark Hall of Fame, Gideon's Trumpet. Additionally, March 18th, which is the anniversary of the Supreme Court decision in Clarence Earl Gideon's favor, has been deemed as Gideon Day. The year 2013 marked the 50-year anniversary of the Gideon versus Wainwright decision of 1963. The Constitution Project produced a 30-minute documentary entitled Defending Gideon, and HBO produced its own 90-minute documentary, Gideon's Army. Clarence Earl Gideon has been called many things, including an uneducated underdog. Yet his firmness in his belief and his resolve to never give up forever changed our criminal justice system, especially for the poor in this country. After the Supreme Court decision in 1963, U.S. Attorney General Robert F. Kennedy wrote, "If an obscure Florida convict named Clarence Earl Gideon had not sat down in his prison cell to write a letter to the Supreme Court, the vast machinery of American law would have gone on functioning undisturbed. But Gideon did write that letter. The court did look into his case, and the whole course of American legal history has been changed." While some may argue that he was not a hero because of his past brushes with the law, Gideon possessed enough spunk and perhaps even stubbornness to take on a task of heroic proportions, taking on the U.S. Supreme Court. That heroic act is still considered by many as a cornerstone of our justice system today. In Gideon's last paragraph of his letter to his Supreme Court attorney Abe Fortas, he wrote, "I believe that each era finds an improvement in law. Each year brings something new for the benefit of mankind. Maybe this will be one of those small steps forward." Part of this quote has been inscribed on his tombstone in the Mount Olivet Cemetery in Hannibal, Missouri. Gideon's letter and case was much more than a small step in the right direction. It set a series of events in motion that changed the nation's legal system, proving that sometimes one person can make an important difference.